Welcome to IP Concerns Deep Dive, the podcast version of our IP Concerns blog from Cascade Law Group. Here, we unpack intellectual property-related, real business and brand protection topics in a way that actually makes sense, no legal experience required.
I want you to imagine, just for a second, that you are standing on a stage and you are live on national television.
Oh, that's already a nightmare scenario for most people.
Right. But, imagine you are wrapping up a massive, defining chapter of your career. Millions of people are watching you.
Okay.
And right in that highly charged, very emotional moment, you decide to make a joke.
As one does on television, I suppose.
Exactly. But this isn't just, a simple one-liner. It is a highly calculated risk that could either go down as a legendary piece of late-night comedy or, and this is the scary part, it could turn into a multi-thousand-dollar legal blunder that infuriates a massive corporation.
Yeah, that is quite a gamble.
It really is, and which way it goes depends entirely on the invisible, incredibly murky rules of intellectual property law.
It's basically the ultimate high-wire act, right? I mean, you are balancing comedic timing on one side and, well, federal court on the other.
Exactly, and we are looking at a real-world legal breakdown of this exact scenario today. This deep dive is based on our source material titled The Colbert Finale, Fair Use or Copyright Infringement.
It's such a fascinating case study.
It really is. We're digging into Stephen Colbert's final episode of The Late Show. He delivered his signature biting humor, but in doing so, he accidentally handed intellectual property lawyers around the country, like the ultimate case study.
Oh, totally. A masterclass in the fine line between legally protected parody and just blatant copyright infringement.
Right. So to really understand the legal mechanics at play here, we need to look at the exact anatomy of the stunt he pulled, right?
Yes. I mean, before we can even judge the legality, we have to look at what went down. It's this perfect intersection of comedy, corporate risk management, and copyright enforcement.
So let's lay out the scene on that stage. Colbert is doing his final show. And during a segment, he brings up a very specific, highly recognizable piece of music.
I think we all know the one.
Yeah, you probably do. It's the jazz introduction to the Peanuts and Charlie Brown cartoons. The song is actually called Linus and Lucy.
Right, and that tune is just instantly recognizable to almost anyone who grew up watching television in the U.S.
Oh, for sure.
And because of that massive cultural footprint, it is highly valuable intellectual property. Like, it is a core financial asset for the estate that owns it.
Well, and Colbert knows this, so he informs his live audience that the copyright owner of this exact song had just recently filed, I think, 4 different lawsuits?
Yes, 4 of them.
Right, alleging copyright infringement against people who used the track without permission. He literally warns his audience, on air, that infringers might have to, quote, pay through the nose.
Which is brilliant because he is laying out the stakes perfectly for the viewers at home. He's establishing right up front that the owners are highly litigious and fiercely protective of their catalog.
Exactly. And then, right after giving that dire warning, his house band just plays a short snippet of that exact tune.
Just right there on the spot?
Right there. They play Linus and Lucy live on network television. And Colbert just caps the whole thing off by joking that he hopes the stunt won't cost CBS any money as an infringer.
It's so brazen.
It really is. I mean, let's put this in perspective for you listening. Fair use in copyright law is often described kind of like an easement on a property.
Right, like a right of way.
Yeah, exactly. You are legally allowed to walk across your neighbor's lawn, but only if you are doing it for a specific legally protected reason like, I don't know, accessing a public road.
Right, you can't just do it because it's a faster route to the bar.
Exactly. But Colbert didn't just walk across the lawn. He walked up to a chain link fence, read a massive beware of dog sign aloud to his friends, and then immediately jumped the fence with a raw steak in his hand.
While claiming he was just using his legal easement.
Yes, that is exactly what it felt like.
I mean, he announced his intention to test the boundary while provoking the dog. And that created this immediate burning question for every viewer.
And especially every lawyer watching.
Oh, absolutely. The lawyers were probably hyperventilating. The question was this a legally protected parody under federal law? Or did he just broadcast a blatant, undeniable copyright infringement to millions of people?
Because he was so openly playing with fire, We really have to look at the exact legal shield he was banking on here. He was relying on federal fair use laws.
And fair use is, it's honestly one of the most misunderstood concepts in all of law.
Oh, totally. People throw it around all the time.
Right. But under federal law, a parody is deemed a specific form of fair use. It's a legal mechanism that essentially says, yes, you use someone else's property without permission, but society benefits from this specific type of usage.
Like commentary or criticism.
Exactly. So the law says, we will excuse it, but, and this is a massive but, it comes with really rigid, unbending rules.
Yeah, it's definitely not blanket immunity simply because you're a comedian holding a microphone.
Not at all. So first, there's the rule regarding the amount used. A parodist is legally entitled to use only enough of the original work to call it to mind for the audience.
Meaning you can't just, take the whole thing.
Right. If you use too much, like if you play the entire song when a 4-second riff would have easily established the joke, you lose the protection.
Wow. Okay.
Yeah, because parody only requires the audience to recognize the target. It does not require giving them a free concert.
That makes sense.
Using too much ruins the defense entirely, which is probably why the house band only played a really short snippet, just enough to trigger that nostalgic Charlie Brown recognition in your brain.
Okay, so that's the amount. The second hurdle the sources talk about is transformative use.
Right.
Which means so in this case, the comedy bit, it has to have a completely different purpose from the original author's intent.
Which is key here.
Yeah, because Viscaraldi obviously didn't write Linus and Lucy to be a punchline about corporate litigation.
No, definitely not. So we have a short snippet and we have a new purpose. That seems, fairly straightforward.
It does.
But the sources highlight a third rule, which they call the targeting rule, or sometimes the golden rule of parody. And this is honestly the crux of the entire legal framework here.
Okay, lay it on me.
To be protected as a parody, the original work, so the song itself, or the copyright owner of the song, they must be the brunt of the joke.
Wait, really?
Yeah. Using a work to make fun of itself or its creator is transformative. Using it to make fun of something else is not.
See, I want to pressure test that targeting rule for a second because it just sounds incredibly subjective to me.
It is very subjective.
If the bit is funny and it's transformative, why does the federal government care who the punchline is directed at? Like, is it basically the difference between drawing a ridiculous mustache on a famous painting to mock the painting itself?
Right.
Versus, I don't know, breaking into a museum, stealing the painting, and just using it as a prop in a comedy sketch about an art thief?
Yes. That is a brilliant analogy. That distinction gets right to the economic heart of copyright law. Think about it from the creator's perspective for a second.
Okay.
If you are drawing a mustache on a copy of a painting to mock the painting itself, you are engaging in commentary. And society really values that exchange of ideas, even if the original artist absolutely hates it.
Right, because you are actually commenting on the work.
Exactly. That is a true parody, and it's protected by the First Amendment. But if you steal the painting just to hang it in the background of your comedy sketch about an art thief...
You weren't commenting on the painting at all.
Not at all. You are just using the artist's hard work as a free prop to make your own product more entertaining. You're exploiting their labor for your own commercial benefit without compensating them.
Oh, wow. I never thought about it like that.
Yeah, if the law didn't require targeting, any television show could just use any hit song they wanted for free simply by writing a generic joke around it.
The economic foundation of creation would just collapse.
Completely. So the targeting rule ensures you can only use the property if the property itself is the necessary subject of the criticism.
Okay, that makes so much sense. That prevents comedy from just becoming this giant loophole for stealing props.
Exactly.
And that targeting rule is the exact tightrope Colbert was walking, right? Like, the whole legality of that broadcast wasn't about the music itself. It was entirely about who he was aiming that joke at.
Yes. It all comes down to what the sources call the Colbert conundrum.
Right.
Because the entire legality of that national broadcast hinges on one highly subjective question. Who was Colbert actually criticizing when the band played that tune?
And our sources lay out two completely different legal realities based on how you interpret that target. So let's look at scenario A first. This is the valid parody defense.
Right. So if you interpret the joke as Colbert mocking the copyright owner, mocking them for being overly aggressive, litigious, and overbearing in their copyright enforcement, then it is likely a legally valid parody.
Because the target of the joke is the owner and the music itself.
Yes. He is commenting on their specific behavior by defying it on air. Drawing the mustache on the painting.
Okay, but then there's scenario B, which looks at the broader context of the show.
And this is where it gets tricky.
Very. Because if a judge or jury determines that the sole purpose of playing the Charlie Brown song was actually to mock his employer, CBS, for canceling his show.
Right. Perhaps due to prior claims that the cancellation was mostly a financial decision.
Exactly. If that's the target, then the whole defense just falls apart instantly.
It does, because in that interpretation, the target becomes CBS. The target is his bosses. The music is just being used as a weapon to poke his employer in the eye.
Right.
And the law essentially says you cannot drag an innocent third party's intellectual property into your labor dispute just to make a punchline.
That makes total sense.
Yeah, if the music is just a prop to attack a third party, it's an impermissible, untargeted infringement. The danger zone, basically.
Reading through this, you can really feel the anxiety of the situation. As a viewer, you watch this happen on late-night TV, and you just assume a massive network like CBS, with its high-priced legal teams, they must have thoroughly vetted this script.
You would certainly think so.
Right. You assume the lawyers looked at it, they sat in a room, debated scenario A and scenario B, and ultimately pre-approved the joke under scenario A, deciding that the target was clearly the copyright owner, no matter how biting the joke was towards CBS's own wallet.
Because, you assume a multi-billion-dollar broadcast corporation doesn't just wing it with federal copyright law on a highly publicized finale.
Yep, that assumption was completely wrong.
It was entirely wrong.
The sources reveal that CBS lawyers did not review and approve this bit beforehand.
Which is wild.
That's insane.
Yeah.
Colbert's on-air warning, when he joked that he hoped the stunt wouldn't cost CBS any money, was entirely prophetic. He literally threw this stake over the fence, and the dog was waiting.
And what a dog it was.
Right.
The copyright is held by Lee Mendelsohn Film Productions, or LMFP for short.
Okay.
They are the owner and the steward of the Vince Guaraldi Peanuts music catalog. And at that specific time, they were already in an incredibly aggressive legal posture.
Yeah, aggressive is an understatement.
Ah.
Just the day before Colbert's finale aired, LMFP had launched a major copyright enforcement campaign.
They were not messing around.
No. They weren't just sending, polite warning letters. They were filing federal lawsuits. They sued video game publishers. They even sued the U.S. Department of the Interior.
Suing the federal government tells you absolutely everything you need to know about their risk tolerance.
It's silly.
The Department of the Interior apparently used Charlie Brown music in a public service announcement video without licensing it. And LMFP does not care about optics. They care about the strict letter of the law.
Right.
Because if a company is willing to take the federal government to court over unauthorized music use, they are certainly not going to flinch at a late-night comedian.
Exactly. So Colbert's band plays the snippet on air, completely unlicensed. Predictably, LMFP noticed.
Of course they did.
But instead of a toxic, drawn-out courtroom battle over fair use, target analysis, and the nuances of scenario A versus scenario B, CBS and LMFP just quickly and quietly struck a formal licensing agreement.
CBS totally capitulated.
They did. They agreed to pay an undisclosed fee to settle the unauthorized late-night performance.
And, we should talk about the calculus of corporate legal defense here.
Yeah.
And why CBS chose to pay rather than fight what could have been a winning battle.
Yeah, why not argue scenario A?
Well, to defend the joke, CBS would have had to go into federal court and argue scenario A. They would have to convince a judge that Colbert's true intent was to mock LMFP, not CBS.
Colbert literally said on air he hoped it wouldn't cost CBS money.
Exactly. And a plaintiff's lawyer would seize on that immediately. They'd say, look, he is clearly taking a shot at his network's budget. CBS is the target.
Oh, wow. Yeah.
The legal fees alone to fight that highly subjective battle would just dwarf the cost of buying a retroactive license. And if they lost, it's not just paying the few $1,000s the license would have cost in the first place. The law allows for what's called statutory damages in cases of willful infringement.
Wait, what does that actually mean in dollars? How much are we talking?
Statutory damages mean the judge can essentially slap you with a massive punitive fine. Sometimes it's up to $150,000 per instance.
Ouch.
Just to make an example out of you and deter future theft. So you don't test a theoretical parody defense against a company that is actively suing the Department of the Interior when statutory damages are on the table. You just cut the check.
Right. It is the ultimate pragmatic corporate move. make the problem go away with a checkbook.
Exactly.
But at this point, this might just sound like another deep dive about a litigious corporation pocketing a settlement over like 5 seconds of a jazz tune.
Which happens all the time.
It does. But the destination of that settlement check is where this entire story takes this unexpected, genuinely wholesome twist.
Yes, the resolution is surprising, largely because of how the copyright holders actually reacted to the joke itself.
Right.
Jason Mendelsohn, who is the chairman of LMFP, he went on the record about the incident later. And he admitted that they actually found Colbert's finale gag funny and entertaining.
They weren't even offended by the joke.
Not at all. They liked it.
But as stewards of the copyright, they were sort of trapped by their own obligation to the property, weren't they?
They absolutely were. I mean, even if you think the guy jumping your fence with a stake is hilarious, you still have to enforce the boundary of the yard.
Right.
Mendelsohn had to use the moment to enforce the hard, unbending rule that businesses, and especially massive networks like CBS, must obtain written licenses for commercial music use.
Because if you let one network slide just because the host happens to be funny,
you weaken your ability to enforce the copyright against anyone else in the future. It sets a terrible precedent.
So they demand the settlement, and CBS pays the undisclosed fee. But because LMFP actually appreciated the humor of this stunt, they didn't keep a single dime of it.
Not a cent.
They announced that 100% of the settlement proceeds paid by CBS were being donated to World Central Kitchen.
Which is just fantastic. That is the disaster relief charity founded by Chef Jose Andres, right? The one that provides meals in the wake of humanitarian crises.
Yes. And there is this massive, beautiful coincidence baked into the timing of all this.
Oh, this is the best part.
On his penultimate episode, literally just one night before the finale where he pulled this stunt, Stephen Colbert himself had presented a massive $2.5 million donation to that exact same charity, World Central Kitchen.
The irony is just perfect.
It really is. Colbert gets to deliver his parting shot on live television, defying the lawyers. The copyright owners at LMFP successfully defend their legal boundary and proves they aren't to be messed with, but without looking like soulless corporate villains.
Right.
And a global disaster relief charity walks away with a nice chunk of CBS's money. It is a rare moment where the rigid machinery of intellectual property law actually facilitated a net positive for everyone involved.
It really is. Clear communication, a shared sense of humanity, and forced corporate philanthropy turned a legal violation into a really satisfying conclusion.
Yeah. What started as a late-night prank with a jazz tune turned into a masterclass on the strict boundaries of legal parody. It proves that in the world of intellectual property, who you are making fun of is quite literally the difference between a laugh and a lawsuit.
It really all comes down to the target, and that is a very human, very subjective assessment of intent.
It is. But before we wrap up this deep dive, I want to leave you with a final thought to mull over, building on that fragility of live comedy and copyright law.
Okay.
Because we've been talking about this situation entirely through the lens of human lawyers, human executives, and human risk assessment.
Right. People making judgment calls.
But I want you to imagine the near future of live television and streaming in an era of advanced, ubiquitous artificial intelligence.
Oh, wow. Yeah, the human element of discretion is completely removed in that scenario.
Exactly. Imagine a world where AI systems are constantly, instantaneously monitoring every live broadcast, and they're running acoustic fingerprinting in real time.
That's terrifying for a broadcaster.
It is. And for anyone listening who doesn't know, acoustic fingerprinting is basically software that constantly maps the unique spectrogram of an audio feed. It turns sound waves into mathematical equations.
So it doesn't even need to, hear the music.
Right. It just matches the math against a massive database of protected frequencies in milliseconds. So what happens if an AI detects an unauthorized musical snippet the very millisecond it happens?
Well, instead of a human lawyer sending a letter the next day or deciding if it's a valid parody, the system just automatically issues a cease and desist order.
Or worse.
Yeah.
What if the system is integrated with the network's financials and automatically deducts the licensing fee directly from the bank account before the broadcast even reaches a commercial break?
Oh, man.
Right. If enforcement becomes instantaneous and completely automated, there is no Jason Mendelsohn there to say, hey, that was actually pretty funny. There is only the algorithm enforcing the boundary.
It raises a profound question, really. Can comedy even survive when the consequences of a joke are administered by an unblinking machine?
How will that change the very nature of spontaneous comedy? I mean, If comedians and their producers know that their network's bank account will be automatically and immediately drained the second a house band plays a recognizable chord, will they ever take those risks?
Probably not.
If the legal tightrope disappears and is replaced by an automated laser grid, will live, boundary-pushing late-night television as we know it, simply cease to exist?
It's a huge shift to think about.
It really is. So the next time you find yourself wrapping up a major chapter of your career and you think of the perfect boundary-pushing joke, make sure you know exactly who you're aiming at. Because the fine line between brilliance and a multi-thousand-dollar blunder is thinner than you think.